Business Organizations. Introduction to U.S. Corporations. Although a corporation is a fictitious, intangible, artificial being, merely a nexus of contracts involving stakeholders, third parties and the state, a corporation is a distinct legal entity, separate from its owners. The corporation pays its own taxes, it can sue and be sued in its own name, buy, sell and own property, and the corporation lives on after the death of its owners. One of the key attractions of a corporation is its ability to shield its owners from liability. The corporation is responsible for its own liabilities and pays its own debts. Unlike limited partnerships, all the owners of a corporation are shielded some liability. The roots of modern U.S. corporations can be found in ancient Rome and other ancient cultures, where entities separate from their owners conducted business and offered some forms of limited liability. In fact, the word corporation derives from the Latin word corpus, meaning body of people. In 1602, the Dutch East India Company Charter was sanctioned by the Dutch monarch. Investors were given tradable share certificates that were indeed traded, sometimes very profitably, on the Amsterdam Stock Exchange. Similar trading companies, such as the British East India Company, were established by charter in the United Kingdom. When early U.S. laws were formed, the states followed English tradition in chartering corporations. Harvard Corporation, a component of Harvard University, was formed in the U.S. in 1636 and claims to be the oldest corporation in the Western Hemisphere. The states held the power to revoke the charters. This made the corporate entity somewhat vulnerable to the vagaries of state governments, until 1819, when the U.S. Supreme Court provided corporations with new rights and rendered the corporate charters virtually irrevocable by the state. Corporations flourished in the United States, but the scope of business each corporation was allowed to conduct was restricted by its charter. A corporation in the U.S. could essentially choose its state of incorporation, and there has been some competition between states vying to attract new companies by relaxing their regulatory controls and offering various incentives. New Jersey was the prominent position until 1913, when Woodrow Wilson passed antitrust laws that were unpopular with corporations, and Delaware quickly established itself as the nation's preferred state of incorporation, a position Delaware holds to this day. As the home for most corporations, Delaware courts handle more corporate cases than any other courts in the U.S. The Delaware Chancery Court has developed specialist expertise in corporate law and established a large body of case law that attracts companies and helps retain Delaware's leadership position. In 1950, the Model Business Corporation Act was promulgated in an attempt to align the corporate laws adopted across the various states. Now revised, the RMBCA has been adopted in 24 states. Delaware is not one of the states to have adopted the RMBCA, neither is California nor New York. Corporations are sanctioned by the state and are governed by state law. Many disputes are heard and settled in Delaware's Chancery courts. Many states follow Delaware's lead. The RMBCA is followed by some states, but differences remain in corporate laws from state to state. Some states, such as California, have established thorough statutes. Others rely more on case law. Although corporations are creatures of the state law, certain federal regulations, such as tax and securities regulation, impact their activities of corporate enterprises. Ownership and control of a corporation is divided among the shareholders, the board of directors, and the officers. It is common, but not necessary, that these roles are played by different people. One individual could act as a shareholder, a member of the board of directors, and act as an officer. Although they own the company, the shareholders do not hold day-to-day control. Control of the company rests with the board of directors. Appointed by the shareholders, the board of directors sets policy and directs management. Management is appointed by the board of directors and usually comprises the president, treasurer, and other officers. The role of the officers is to administer the directions of the board of directors. There are broader classes of stakeholders holding interests in the corporation, including the employees, customers, suppliers, and creditors. Of course, the activities of larger corporations often impact the local community, trade unions, and government. Limited liability for shareholders is a key advantage of the corporation. The creditors of the corporation are restricted from reaching through to the shareholders for payment of the company's debts. By contrast, liability is not limited in a partnership where all partners are fully liable for the partnership's obligations. Trading in shares in a corporation is somewhat easier than trading an interest in a partnership. Although LLCs are relatively new, the corporate form of business has been in existence for many years. Almost every dispute involving stakeholders has been resolved in the Delaware courts and other state courts, and a large body of case law has settled virtually all the significant questions that might arise. This body of law is understood and accepted by investors. So although LLCs appear very appealing, entrepreneurs looking to raise finance from outside investors today often choose to incorporate. The fact that the corporation is a separate entity means it's able to shield liability from its owners, but it also means it has to file its own tax returns and pay its own taxes. This can result in double taxation. The owners and the corporation each pay taxes. The corporation pays taxes on its profits, then distributes the profits as dividends, and the shareholders pay taxes on the dividends they receive.